Okay. Good evening, everyone, and welcome to our Estate Planning 101 webinar. Thank you very much for joining us tonight. My name is Angela Dennerson, and I'm a Senior Business Development Officer with the Los Angeles Police Federal Credit Union. Before we get started, I'd like to mention that this session is a live webinar, and a recording will be sent shortly after. You will be in listen-only mode, but our presenters will be answering questions in real time during the presentation. So we encourage you to type in your questions in the chat box located at the bottom of the screen. Please send your questions to everyone, not just the panelists, because we know there's going to be a lot of great questions out there and we want everyone to get the information. We scheduled this webinar for an hour presentation, but we're confident that all the material can be covered in half an hour. So we're going to give you some of your time back. The gift of time, right? So enjoy that tonight. If we can't get your questions tonight, though, we will give a link to the chat for your questions so you can ask them in the chat and someone will get back to you as quickly as possible. Also, we are raffling off a free estate plan courtesy of Trust and Will, our presenter tonight. Members who watch this live webinar in its entirety will automatically be entered to win. The lucky winner will be contacted tomorrow. So please, stay on. Now I'd like to introduce our speaker for the evening, O'Neill Dewey. O'Neill, take it away.
All right. Thank you, Angela, and welcome Los Angeles Police Federal Credit Union members to today's estate planning webinar. I am your host today, and I'm about to share my screen. So let's see if this works. All right. So welcome again. I'm your host. My name is O'Neill Dewey. Believe it or not, my first name is O'Neill. I manage our credit union partnerships here at Trust and Will, and I'm joined today by Jason Young from our member support team, who is manning the chat box. So if you look to the top or bottom of your screen, I'm not sure exactly where it sits on WebEx, but you should see a chat bubble. That chat bubble, please make sure that it's marked on chat to everyone so that everyone who's attending today can view and see all of the great questions and answers that come through. Jason will be manning the chat box, answering questions as soon as they come through. So please, instead of remembering your question to ask at the end, ask your question immediately when you have it as we go through this estate planning webinar. And Jason will be fielding them as soon as they come in so you can get quick answers as we go throughout this presentation. So I want to walk through what we'll be covering today, and that will be the basics of estate planning. So we're going to start by defining why an estate plan matters and what an estate plan is and does. Then we'll cover some of the key documents in an estate plan and how to decide which documents are best for you. And finally, we'll conclude with who needs an estate plan, some of the most common reasons it might be time to create or update your plan, and how you might get started doing so. Again, throughout this whole presentation, as you have questions, make sure you ask them within the chat bubble, within your WebEx, so that you can get live answers from our member support. And before jumping into the basics of what is estate planning, I want to quickly give some background as to who I am and why I'm presenting to you today. So some context is that Los Angeles Police Federal Credit Union chose to partner with Trust and Will to help members create or update their estate plans. Our website is entirely online. We've helped over 1 million families across the United States to create or update their estate plan documents in all 50 states. And we've partnered with over 200 credit unions across the country and have thousands of 5-star reviews from their members. So we're available to help you actually take action once you've done a little bit more educational learning by the end of this webinar. Hopefully we can get through all the content in 30 minutes or so, and you can actually complete an estate plan in about 30 minutes through our website as well. So maybe in this 1 hour, you can go from learning about estate planning to actually going ahead and tackling that for your family. So to start, what is estate planning? Estate planning is planning today for what happens tomorrow. At its most basic level, an estate plan lets you make decisions today about what should happen if you are unable to make decisions in the future. This set of instructions specifies what you want to happen to your assets, your belongings, and your physical body. And it's important to know that estate planning is the largest personal transaction of your life. Unfortunately, that said, typically it's also a piece of financial well-being that is least prepared for by families. Without a plan, most people end up leaving their assets and legacies subject to probate, which means the government makes all decisions on your behalf. And unfortunately, nearly 2/3 of American adults procrastinate on their estate plan until it's too late. The three primary reasons of doing so are a lack of education around the risks of not having a plan, the cost. You can typically expect to pay thousands of dollars to draft estate plan documents with a traditional attorney, and inaccessibility when it comes to not knowing who to turn to get things done correctly the first time. So again, Los Angeles Federal Police Credit Union has partnered with Trust and Will to help you through these hurdles, but at the very least, we can help educate you on why estate planning matters. So, why should someone care about estate planning? What should motivate someone to create their estate plan? There are many reasons to care, but first and foremost, it's peace of mind. You will feel confident that you've taken the necessary steps to protect yourself and your loved ones once you've gone through this process. You'll also be able to name legal guardians to care for your minor children, as well as your pets if you have pets. Another reason estate planning is important is that it can help you prepare for potential incapacity during your lifetime. So studies show that most Americans will be impacted by incapacity, whether it's your own or a loved one during lifetime. And because this happens during your life, it can often matter most to some people who are planning ahead. And these are inherently personal decisions. There is truly no easy way to have a default rule that matches everyone's desires, and there's no certainty that other people making decisions on your behalf would make the same decisions you would want for yourself. And so that's why it's important to plan ahead. And when it comes to estate planning, primary motivations can be asset distribution and business succession planning. Those are two big elements. Asset distribution is the ability to control where your assets will go after your death. You can choose to have assets benefit family and loved ones, to support charities, organizations, and causes that are personally meaningful. And you can also plan on using an estate plan to minimize taxes and maximize the benefit passed through to your beneficiaries and loved ones. And many people equate estate planning with asset distribution, right? When you think of a will, you may think of where your assets go. And that's certainly a big part. But asset distributions are not the end all be all of estate planning. And there's a number of other factors to consider as well. So we've gotten the why down, but what is an estate plan? An estate plan is a set of documents containing instructions for what should happen if you cannot speak for yourself, whether you're incapacitated or have died. An estate plan is typically multiple documents, it's not just one, and the documents in a plan will vary person to person, but should be tailored to meet your specific needs. Each type of document is designed to do one thing. Your plan may focus on just one or two of these things, in which case you may have just one or two, major documents, or your plan might be more comprehensive with a full suite of documents. But most typical estate plan documents are wills, trusts, and healthcare documents. So we're going to dive into each one of those categories today. Your last will and testament is a legal document that controls most assets when you die. It goes into effect after your death. So, what's its purpose? A will handles fundamental needs for everyone. Therefore, if you are at least 18 years old, a will can benefit you. And there are three primary functions of a will. First is to determine who will receive your assets after you die. Second is to nominate guardians for your children and pets. And third is to specify your final arrangements. For example, do you want a traditional funeral or memorial? Would you like to be buried or cremated? There's a number of decisions there. So, what's the next logical question most people have? What happens if you die without a will? And the answer here is that the functions of a will are essential. These matters who will get your things and how assets will be distributed. They have to be addressed, even if you don't have a will. And so what happens if you die without a will is that state laws will fill in gaps to make decisions for you. This is one of the most common misunderstandings when it comes to estate planning. Many people assume that, oh, the default state laws will give me the same results as I may have wanted for myself anyway, but that really is not always the case. And I want to give you an example today to really illustrate that for you. So, state laws, depending on where you live, may provide that your assets are divided, or a scenario itself, right? You're married with two children, and the state laws may provide that your assets are divided 1/3 to each family member. And you may not want your kids to get 1/3 of all your assets immediately when you die. And your spouse might not be able to maintain a house or standard of living with just 1/3 of your assets. And depending on state laws, this is what could happen if you die intestate. However, with a legally binding will in place, the court will likely honor your wishes as stated. So we're going to focus a bit more on how a will works after death. Wills go through probate, which is a judicial process to determine the validity of a will and to appoint an executor. If you don't have a will, the court will appoint an administrator to perform the same functions as an executor, which is typically a relative. But if you have no will, it may not be the person that you would choose for yourself. And the executor, once appointed, is the manager of the probate process. Their job is to collect assets, to pay off any debts, expenses, and taxes associated with the estate, and then to distribute the remaining assets to beneficiaries. But probate is often undesirable because, first off, it's slow. Before COVID, it was taking 12 to 18 months in California. And after COVID, you can expect 24 months and beyond in some courts now. So it can be a very, very slow process to actually pass through those assets to beneficiaries. Second, it's difficult and it's stressful. The probate process begins immediately after death during a period of grieving for a loved one's loss. And because of this, it often brings out resentment and can lead to disputes within families and loved ones. And third is it's expensive. In some states, $1 million estate can cost $50,000 in statutory fees for probate. That's in California, for example. And so probate avoidance is a huge motivator for some and is one of the primary reasons that many people will look to set up a trust. A trust is a legal agreement between three parties. There's the settlor, trustor, grantor, who creates trust and puts the property into it. There is the trustee who holds and manages the assets in the trust. And then there's the beneficiary who the trust is in favor of. So basically, the settlor creates a trust and gives assets to the trustee to hold for the beneficiaries. There are a number of purposes, primary purposes that someone might set up a trust. We talked before about probate avoidance, which is key for many people. A trust is an easy way to avoid all those negative consequences we just discussed of probate. But a trust is not only about probate avoidance. Another reason is to manage and distribute assets with more control. And a trust gives you that additional control over how assets are distributed. So for example, you can add contingencies to your trust. A trust applies both during lifetime and after death. So this means a trust can be useful in planning for incapacity and can ensure that there's a seamless transition of control. And a trust can provide for your family, which is a big motivator for many people with younger children and blended families. Trusts give more control over assets that will eventually benefit your younger children. Trust can also give you more control over providing for your spouse for his or her lifetime, but then ensuring those assets pass to your children after your spouse's death. And a final reason that's very popular is that to minimize taxes, which some trusts can do depending on your wealth bracket. And so, what is the role of a trustee? A trustee is basically like the CEO of a trust. You're bound by law and terms of the trust, but it's still critical role in executing the duties. A trustee can work with other professionals and advisors as well. And so when you're choosing a trustee or considering who to choose, you want to choose someone who has the ability to carry out those duties. So popular choices are a spouse, a child, or children, relatives with more managerial experience, or close friends. And there are four buckets in general when considering types of trusts. Revocable living trusts are the most commonly used type of trust. When most people think of a trust, they're thinking of a revocable living trust, and these are created while living. They can be changed or revoked, and the assets within will avoid probate. Another popular type of trust is a testamentary trust. These are a little bit less commonly used, but they're created under a will, in which a testamentary trust is only effective at death. And these can be easier to create, but typically do require probate. Some other, depending on the complexity of your personal situation, your estate, there are other types of trusts to consider as well, including those used for tax planning purposes. Examples of those may be credit shelter trusts, Q-tip marital trusts, irrevocable life insurance trusts. And there are also trusts used for purposes such as for other unique purposes. Uh, Special needs trusts, asset protection trusts, Medicaid planning trusts. And so that was a lot about trust. Let's help you understand the similarities and differences, because some do things that others do not. The similarity with both these estate plan documents are that both documents dispose of assets. Some key differences are that trusts avoid probate, wills go through probate. Trusts give greater control over when and how assets are distributed. Wills can be easier to set up. Trust can be a little bit more work, generally speaking, and trusts apply during lifetime. Finally, wills can nominate guardians and specify final arrangements. And big picture, trusts are usually paired with a will as a set as well. So if you're setting up a trust, you're likely also setting up your will alongside it. All right. Where were we? Okay, so when should you consider a trust? One reason is if you have younger children. Rather than having all assets go to your kids immediately when they turn 18, a trust can let you set triggers for asset distribution. So some trigger examples could be turning a certain age or hitting some life milestone. You could, within a trust, specify assets to be distributed upon graduation or getting married, or some life event like that. And they can also help stretch out distributions. Another reason a trust may be considered is if you have complex family dynamics. So blended families, second or third marriages. In these instances, trust can let you benefit your spouse for their lifetime, but then ensure your assets go to your kids and not to a second marriage or stepkid. Another reason is privacy. Wills become public through probate, whereas trusts stay private. And a final popular reason is if you have higher asset levels. Trusts avoid probate, which in California, I believe, at least historically, kicks in with estates around 160,000 in assets. With trusts, you can minimize estate and income taxes. Federal estate tax, I believe, kicks in around $13 million today. However, that could be lowered based on the administration in office at any point in time. I know that's top of mind for a lot of people. And then trusts provide the opportunity for more advanced planning and can help you stretch out retirement distributions in some cases too. So if you have retirement savings that you plan to leave to your beneficiaries, a trust may provide a tax advantage way to distribute those retirement savings over time. So we've covered wills, we've covered trusts. Let's talk about the third most common estate plan document, which is your healthcare documents. And those are typically they're made up of three different types. You've got your power of attorney, your healthcare directive, and HIPAA authorization. And these documents cover what happens when you are incapacitated. While a will or trust covers what happens to your property when you die, this part of your plan covers your wishes for your finances and care while you're still alive. Your power of attorney designates someone to make non-medical decisions for you. Those would be financial decisions, business decisions, handling of any day-to-day transactions, bills, things like that. Your healthcare directive or also known as a living will, specifies your medical preferences in advance and designates someone to make medical decisions for you when you are not able to voice them. And finally, your HIPAA authorization, you may have signed something like that in a doctor's office. It ensures your designated agents and representatives can speak with your medical providers in order to make decisions on your behalf, considering costs of treatment and things like that. And it also ensures that stakeholders in your care have access to your private health information and can communicate with care providers about your medical history and decisions, which is a piece that's frequently overlooked, unfortunately. So, who needs an estate plan? You're probably thinking, do I need an estate plan while you're on this webinar today? And, big picture, to be blunt, all adults need an estate plan. And common reasons to create a plan are marriage, children, grandchildren, pets, accumulating assets, any medical concerns of you or loved ones, dealing with the loss of a loved one. It can be a reminder that you're mortal as well and that you should plan ahead. And then just generally speaking, approaching retirement as well. And your plan should evolve as your life does. And you'll want to make sure your wishes are properly reflected as your life changes. There may be some people on this webinar today who have created a will at some point in the past or a trust. And it's likely that, every few years your documents are going to fall out of date a little bit. So moments where you might consider updating your estate plan documents are when you're thinking about updating beneficiaries, changing guardians as your kids get older. They may need different guardians, and generally speaking, you're likely just going to have different preferences for your plan as you age. And some of the more common triggering events to update a plan include major life events, right? Births, deaths, changes in marital status, retirement, and the general passage of time. On a typical rule of thumb, we like to say that every 3 to 5 years, it's certainly worth revisiting just to make sure that those decisions reflect your wishes today. And as children become adults, if anyone here has children themselves, they'll need their own plan. While your child is under 18, you have parental rights. However, once your child turns 18, they need to have legal documents to let you act on their behalf. So just something to keep in mind as well. You can pass this trust and will offering along to your kids as well. And once you've chosen your plan, you'll need only a few things to get started. I really promise this is not as intimidating as you might initially think. You'll need basic information like you, your spouse, and your kids' full legal names and birthdays. You'll need an idea of who you might want to act as guardians for your children and who you want to appoint as your executor trustee, and how you might want your assets distributed, right? What percentages or dollar amounts and to whom. And you can include specific assets. You could list off any specific jewelry you have, any cars, cryptocurrency, really like any kinds of assets you have, and pass through those items to specific individuals if you'd like. Or you can simply say, I just want a portion of my estate to go to these specific individuals as specified. And lastly, you'll need the names of financial institutions where you hold accounts, as well as any addresses to real estate you may own, and if applicable, the names of any businesses you own. But really, it's just that kind of high level information that's needed. That's it. What you will not need are social security numbers, bank account numbers, online passwords, real estate titles, or any relevant business ownership paperwork. Like I said, it's really not as complicated and scary as most people assume. And if you're not quite ready to get started yet today, if you have additional questions, Trust and Will, our website, if nothing else, is loaded with educational content that helps answer common questions and address, items that people have lingering concerns or questions over as it relates to estate planning. So feel free to jump onto our website and browse around and click through some Learn Center articles. We've got hundreds of articles and videos as well. And you'll also have representatives from our support team like Jason on the call today, helping to answer questions in a live chat through our website as well. And so on that note, I want to spend a few seconds today just sharing a little bit more about Trust and Will. We are the leading digital estate planning provider in the United States. We've helped nearly 1 million families across the country to create their estate plan documents, and have partnered with hundreds of credit unions and other esteemed financial institutions and conservative large organizations that are part of your everyday life, to provide our estate planning solution to their members, their customers, even their employees. And so we're available to help support your needs through your membership with LAPFCU. You get a 25% discount off of our retail rates. This is a limited time offer that expires at the end of the month. So please take advantage of that offer in October to get 25% off discount. It is an entirely digital experience. You can think of us sort of like TurboTax for doing your taxes. It's a similar process. You answer one question at a time as you move through this estate plan process. And we have two major packages. We have a will-based package and a trust-based package. So we make it really simple for you. Our will-based plan includes your last will and testament, living will, your HIPAA authorization, your power of attorney documents, so all of those supporting healthcare documents as well. And your trust package includes everything in that will plan, as well as a revocable living trust and a certificate of trust and schedule of assets. So it's two affordable options. Our will prices retail, they start at $199. It's only $200. Our trust package starts at $499. And so that, compared to what you might get quoted approaching a local attorney to draft very similar comparable documents, we're going to wind up saving a lot of time and money, and we can help the majority of people on the call today. And if we aren't a good fit for you, we'll let you know as well. Our member support team can jump in and help answer questions and say, hey, Trust and Will, you have a more complicated situation, and it may be worth setting up time with an attorney to review and draft these documents, just given your life circumstance. So we'll be the first to let you know as well. So with that said, I really appreciate your time today. I hope this was helpful and educational. We're going to stick around to answer some more questions, but I'm going to pass it off to Angela with a little bit more information about the partnership and some additional subsidies or discounts you might be eligible for.
Thank you so much, O'Neill. That was great information. If you do have further questions, if we're still on, please enter them in the chat and Jason will answer them as quickly as possible. If we don't get to your question tonight, there's this QR code on the screen. It'll take you directly to the partnership page with Trust and Will, and there's a little message icon at the bottom. So you can chat in your questions there, and then someone will get back to you as soon as possible. And now, if you're still with us, congratulations, because you have automatically been entered to win a free estate plan with Trust and Will. We'll be contacting the winner tomorrow. If you are not the lucky winner, but you are still in luck because the whole month of October, he brought up, it's a 25% discount on the estate plan with Trust and Will. Right now, it is the best time to get your estate plan and enjoy that extra savings, because usually it's a 10% discount. So take advantage of that extra discount. I also wanted to mention, if you are a member of the Los Angeles Retired Fire Police Association, you might be eligible for a reimbursement up to $600 that goes towards an estate plan. You can go on their website or contact the association directly with more details. Again, thank you so much for joining us this evening. We truly appreciate your membership with LAPFCU. And if you have any questions, again, go on the QR site. You'll have my information. Contact the credit union and we'd be happy to help. O'Neill, anything else to add?
Jason is still in the chat helping to address any questions. As I'm going to drop in a few links for anyone who's still on the call, so that you can explore a little bit more information about our partnership with LAPFCU. So please feel free to check out those two links. and you can get started in just a few clicks through our website. The If you use the links that I shared, that discount will be automatically applied, so you don't need to remember any discount codes or anything like that. And while we won't, we can't necessarily walk you step by step through the process with a live person on the phone. We can help answer your questions as you go through this process. So it's a very intuitive process. You're only asked one question at a time. There's additional education on every slide. And if you do have a question about, beneficiary designations or how to choose a guardian or, any of these different elements, you can open up a chat with our team and we can help support you and guide you to education to make those answers. We also do have attorney support available. For an additional $300, you can actually connect and speak with an attorney multiple times to review the documents that are created through Trust and Will to ensure they meet your wishes and to get legal advice provided to you. So that's available across the country as well. And some people just sleep better at night knowing they've spoken to an attorney. So that's something you can do through our website as well. But you certainly don't need to. If you'd like to go through without speaking to anyone, you want to do this from home tonight in your pajamas without speaking to a stranger about complex family dynamics that you may have, you can do that as well. And so we're available to help and hopefully can as you have additional questions, you can get those questions quickly answered through our website or through Jason, who's in here typing away. So there's a question I see. Is it similar to what LegalZoom offers? Yes, there are a few other legal service providers that exist online, and there I can't speak to every service necessarily, but ways that we stand out from other service providers is that we have this program that is specifically designed for credit unions to support in various different ways. We are the preferred or exclusive estate planning provider of hundreds of financial institutions, including some of the biggest banks and credit unions in the country, as well as yours. And those institutions have thoroughly vetted all the different options out there and have chosen Trust and Will to be the preferred solution for their members. So our estate plan documents are really clean and clear, and the user experience is really nice. You'll see as you go through the process, it's very intuitive. Our member support is available 5 days a week so that you can get questions answered, and we have that attorney function as well. So there are a number of reasons why people choose Trust and Will, but feel free to run your own vetting or do some research on your own. But just know that LAPFCU did some of their own, and they chose Trust and Will. Are the documents legal? So these documents are generated to comply with state laws wherever you are. You specify early on what state you're drafting these documents in, and oftentimes to make these documents legally valid and those that can stand up in court, you'll need to go notarize those documents. So that's a next step beyond Trust and Will. You can oftentimes go to your credit union branch or to a local, FedEx or UPS or Staples. There's all sorts of different notaries, but
Let me interrupt you real quick, O'Neill. Actually,
sure.
there are notaries at every single branch, multiple notaries at every single branch of the credit union. So stop by any LAPFCU branch and you can find a notary there.
Great. So that makes it super easy for you. You can draft your plan online. You can print it out from home, or you could get it shipped and printed and shipped to your door in a nice package. And then you could bring that package in, or the printed plan in, and you can get it notarized at your local credit union branch. So at that point, it becomes legally valid documents. If you have created estate plan documents in the past, that notarization process clarifies that this is the most up-to-date estate plan. It will override past plans as it's been legally accounted for through that notarization process, in which it gets time-stamped as well. All right. I think it looks like we got a lot of these questions answered. So thanks again for everyone who joined tonight. We really appreciate everything. Our police force has done to protect our community, and it means a lot to be able to give back and help you all plan ahead for your own financial future as well, to make sure that your loved ones are protected and secure as well. And so please reach out on our website if you have any questions. We hope we can help you. At the very least, we hope that you learned a little bit today about estate planning in general. And thanks for everything. Have a great night.
Thank you, everyone. Again, we will look at these questions, and if we didn't answer them, we'll get back to you. So we will contact the members who ask us to be contacted. And again, if we didn't get to your questions, we'll go through them and be sure to send you the answer. Thanks, everyone. Have a good night.